So we'll start with dual practice. I think I've also given one of the assignment questions on dual practice. Okay, whether it is possible for the practice of law to be combined with other occupations. Is it allowed under the Legal Profession Act or not? Okay. If you look at section 30, do you have your LPA with you? Go
Yes,
to
doctor.
section, yeah, go to section 30. Okay. If you look at 30 cross subsection 1B, okay, advocate and solicitor shall not apply for a practicing certificate unless he is or is about to be employed full-time in his practice in Malaysia by an advocate and solicitor or a firm of advocates and solicitors in practice. So that is a very strong indication that dual practice is not tolerated, yeah, under the LPA. But we shall look at whether this is absolute or not. Okay, the prohibition here. Okay, if you look at C as well, there is also another indication of the prohibition of dual practice in general. Yeah? If he is gainfully employed by any other person, firm or body in a capacity other than as an advocate and solicitor, right? Unless if the person is serving in the judicial and legal service, a qualified person shall not be construed as being gainfully employed. Okay, if he's serving in the judicial and legal service. What we want to focus more is on B. Yeah? He is to be employed full-time, yeah, in his practice. All right, and you should also read this provision with section 44 of LPPE. Okay, that an advocate and solicitor shall not actively carry out any trade or be on full-time salaried employment, right? Of any person or firm. Do you have your LPPE? If you have the blue act with you, it's somewhere at the back. Okay. Section 44. Have you found section 44? Okay. An advocate and solicitor shall not actively carry on any trade which is declared by the Bar Council as unsuitable for an advocate and solicitor to engage. And B, shall not be a full-time salaried employee of any firm or corporation so long as he continues to practice. Okay, and what's the difference between A and B? If you can, identify. Anybody? What's the difference between A and B? Anybody? Are you with me?
Yes, doctor. B is about full-time salary employee of any persons. Meanwhile, A is about an active partner or salary officer.
Yes, the first one is A is about carrying on any trade. Okay, so I shall do some amendment here. Shall not actively carry out. A is any trade, yeah, which is considered unsuitable by the Bar Council. Okay. Any trade, or B on a full-time salaried employment. Betul? Ada dua keadaan, right? So,
Yes.
first, if you can see, it's about you having a business, right? So, it's about you having a business, and the other one is being employed by another person while you are also
Full-time.
carrying out your legal practice as an advocate and solicitor. So this must be cited lah here when questions come up and ask you about dual practice. You must cite these provisions, yeah. So Chapter 12, Rules and Ruling of the Bar Council allows advocates and solicitors to carry out other businesses on part-time basis. Okay. As long as such businesses are not compatible with the legal profession, yeah. So let's see the rules and rulings which you can obtain from, I think, the website of the Bar Council. I hope I pasted the right URL. Okay. So this is under Chapter 12, yeah? Engaging in other businesses and professions, yeah? Can you see the screen?
Yes, doctor.
Okay. So please have a look through 1 and 2 under Rule 12.01.
Doctor.
Yes.
The screen is still on your slideshow, not on the browser that you opened.
So you can see the URL page or my slides now?
Your slides.
Oh, okay. Then I have to minimize.
You have.
Okay,
Yes.
now. Okay. So there is like a leeway, some kind of leeway provided in these rules as to engagement in other business or trade that that is in the opinion of the Bar Council not incompatible with the dignity of the legal profession. Okay. Part-time, the word part-time, you have to bear in mind, yeah? The word part-time, not full-time, yeah? For instance, if I were to practice and at the same time I'm not letting go of my full-time profession as a lecturer, do you think I'm allowed under LPA?
Yes. Hello?
Profession, full-time profession, yes. Boleh dengar ke?
Saya macam putus-putus.
Kena mutekan your mic supaya tak ada bunyi lain, ya. Right? Okay. Listen first, yeah. I'm just curious whether you are with me or not. I explained to you under LPA just now. Okay, section 30. An advocate and solicitor may only apply for a practicing certificate if he is to be employed full-time in his practice. So I asked you just now that if I were to practice, but at the same time, I'm still teaching full-time, would that be prohibited under section 30?
Yes, doctor. I think it would be prohibited because given that is a full-time lecturer, if part-time I think it would be okay, but full-time I think that would be prohibited under section 30.
So I hope you are clear. Section 44 as well. You shall not carry out any trade. We're talking about businesses here, yeah? Or be on a full-time salaried employment like myself, okay? Being on a full-time salaried employment, I am like a government servant, yeah? I receive my monthly pay and I'm not giving up my current profession. I can't be a full-time advocate and solicitor. So ini adalah rules under the general conduct, you must understand, yeah? But if you go back to these rules, yeah, which I think are issued by the Bar Council, okay? If you look at 1, yeah, sub 1, an advocate and solicitor who is a sole proprietor or a partner, tengok siapa, sole proprietor or a partner. So you have to make sure you quote the right provision. We're not talking about a legal assistant yet, right? May engage on a part-time basis in a business or trade that is in the opinion of the Bar Council is not compatible. So let's go to sub 2. An advocate and solicitor who is a legal assistant may engage on a part-time basis in a business or trade that is in the opinion of the Bar Council not incompatible with the dignity of the legal profession, provided it doesn't infringe his or her full-time employment. Okay? So it makes also a reference to section 30 clause 1b just now. Right. So what if I tell you that I'm a full-time advocate and solicitor, okay, whether a legal assistant or a partner or a sole proprietor, and I wish to teach part-time at USIM Law Faculty, would that breach the Legal Profession Act?
Yes, doctor.
Okay, why?
Because it's a part-time lecturer at FSU.
Anybody has a different answer? If I were a legal assistant, a lawyer, yeah, an advocate and solicitor, a qualified person under LPA, and I'm also doing a part-time teaching job, okay, at the law faculty, all right? Would that come under any of the prohibitions just now?
No, doctor.
No.
Okay.
No.
Anyone can explain in detail why am I not caught by the provision of LPA?
Because in section 30 of LPA 1976, it's clearly mentioned that it is prohibited if the person, if the advocate and solicitor applying for practicing certificate, and he must fully employed as a practitioner. Therefore, if the advocate merely or just only teaching as a part-time, So it is permissible. According to Section 44 also, advocate shall not actively, shall not do a full-time salaried employment. However, as a part-time, it is permissible.
So you have to understand, yeah, not only Section 44. So thank you for your answer. I think you are, you are with me, yeah, on Section 30, 44, 12. But you must also not forget to cite rules and rulings of the Bar Council that I shared with you just now. Yeah, this one. Okay. So this specifically is explicitly allows for either a sole proprietor or a partner or a legal assistant to engage on a part-time basis. But would that be, an absolute exception? What is the proviso here? Anybody?
Doctor, we cannot see the Malaysian bar rulings. It's stuck at your slide.
Okay, now can you see?
Still stuck, Doctor.
Sekejap ya.
Oh.
Ada yang boleh nampak tak?
No, Doctor.
No, madam. Saya tak nampak.
Sekejap.
Saya tak nampak juga.
Okey, sekejap ya.
I think you have to unshare this slide first, then share that bar rulings.
Okay, hold on. I'm trying to do something here. So I'm copying the same provisions that I just read. Susah nak share unshare ni. You can log on to the website, nanti you boleh tengok sendiri. Now can you see the provision here?
Yes.
Boleh baca sekejap? Sorry. Okay, can you read? On a part-time basis, yeah? Can you see my cursor?
Yes, Doctor.
Okay.
Yes, Doctor.
Okay, for one, we're talking about a sole proprietor or a partner. Okay, sama ada you buka sebagai sole proprietor, sebagai the sole owner of the firm, or you being a partner. Okay, for this one, you being a legal assistant. So I was asking you, what is the proviso, okay, for you to be able to engage in other business or trade on a part-time basis, according to this rule? Anybody?
It must compatible with the dignity of the legal profession.
Must be compatible with the dignity of the legal profession. So it is something that is subject further to the Bar Council's decision, right? So you can't be engaging in just any other business or trade, okay, but it must be in a trade or business that will not jeopardize the dignity of your legal profession. Okay, what does it mean by this? So we shall look at if there are any cases maybe. So this one is the same thing, I think. I already pasted it. Okay. legal profession as the only profession in Malaysia, right? Ada a few cases that I found. Maybe you can go to more recent cases, perhaps through your research later on dual legal practice. It would be interesting to see recent decisions on or rulings on lawyers being reprimanded for engaging in another profession that may have jeopardized the dignity of the legal profession. So in Syed Mubarak and Majlis Peguam Malaysia, the person was a public accountant in this case, and he also chose to become an advocate and solicitor. Okay, so he was disqualified, yeah, under section 31C, yeah. And in re and advocate, the issue that arose was whether the advocate and solicitor's engagement, yeah, in another trade, which was actually focusing on selling ladies' garments, was something held as compatible or incompatible to the legal professions. It was held that this was incompatible to the legal profession. Okay, so it actually breaches Rule 44 that prohibits lawyers from carrying on businesses which are incompatible, yeah, for an advocate and solicitor. So this is one example of incompatibility that is meant by the ruling just now. Okay. What if you being an advocate and solicitor, you are involved in, for instance, you are involved as a part-time agent of direct marketing yang ramai orang buat. Would that be something compatible or incompatible in your opinion? Direct selling. Ramai kan orang buat duit jadi agent direct selling.
Betul.
Would that be compatible? So you must be careful, ya. Nanti boleh, you can be subjected to some kind of disciplinary hearing or proceeding. Alright? If you happen to cross the limits, okay? So you have to know the limits, what you can and you cannot do, right? Jadi ejen Syakli ke, jadi apa lagi? Jual kerepek ke apa, right? So kalau ada yang report, okay, ada your someone in the same profession, okay, who is unhappy with you, they report about your activities di luar daripada law firm, then you can be in trouble, right? So that's why we are learning about ethics of being an advocate and solicitors, right? Alright. Right. No acting for more than one party. You're not supposed to act for more than one party. This one is under Order 7 or Solicitors Remuneration Order 2006. In any transaction referred to the first, second, third and fourth schedules of the order, a solicitor shall not act for more than one party in a particular transaction, right? So please refer to the content of the schedules, okay? But notwithstanding section 1, a solicitor may, where there is no conflict of interest, prepare, file or witness the miscellaneous documents specified in the fee schedule for another party to the transaction. You ada dalam list of orders tak? The Solicitor's Remuneration Order, is it part of the sub-regulations in your LPA?
Yes, the page 326.
Okay, boleh tengok sekejap tak? boleh tengok schedule yang listed in order 7 tadi. Is it 326 or 321? So look at the back pages, yeah. So first, second, lease and tenancy is the second. The first one involve I think sale and purchase transaction, right?
Yes.
What about third? Charges, debenture and other securities. So the third one concerns with charges, security, debentures, okay, those types of transactions, yeah. Fourth, schedule, discharge of charge. All right, so in this schedule, matters that fall within the schedules, a solicitor shall not act for more than one party, okay, because of the possibility of conflict of interest that might arise between the parties that you represent. Okay, mungkin you want to act for both vendor and also purchaser, okay? Or maybe for the banker as well, the financial. This is a bit risky, yeah, because you may not advance the best interest of your clients because you're acting for the other side of the for party on the other side involved in the transaction, okay, involved in the bargaining and negotiations. So this is a reason why it is always best to act for one party, right? So let's go to this the Malaysian law. This URL actually expounds a very good note on conveyancing activities, ya. Kalau boleh you tengok sekejap. Okay, I try to unshare my slides. So how do I unshare? Okay, unshare and then have to go. Okay, I'm trying to go to the URL page. Share my screen. Can you see now?
Yes, Doctor.
Yes, madam.
If you as a lawyer are involved in conveyancing transactions, so you must have some basic understanding of sale and purchase, okay, and also of charge and discharge transactions. These are some basic transactions that most lawyers are engaged with, okay, in the context of conveyancing. So what are the documents or legal documents that you have to deal with, okay, for such transactions? Just take a quick look at this. So it depends on whether the property that is involved in the transaction has a title or not, sama ada telah terdapat grant that has been issued, okay, for that property, okay. for instance, if you're actually representing a client who wishes to buy or to sell an apartment unit, then we're talking about strata titles here. Okay, so in reality, when you buy a property, after you make the purchase price, after you have completed the legal documents and execute them, you need to have the wait time. You need to wait before the strata title is issued in your name, and that usually involve 1 year or more than that. You're lucky if it's quick, and normally it's time consuming, right? So in other words, you're buying a property that is without a title. Okay. So when a property is transacted without a title, the legal basis of the transaction changes. Okay. So what lawyers will do are to actually create legal documents to assign the rights to the new buyer. So you tak boleh pindah milik lagi. What you have to do for your client is to assign your client's rights to the new buyer, to the new purchaser. Are you with me?
I don't really quite understand about that, Doctor.
Okay. So katakanlah ya, there's one transaction of a sale and purchase of an apartment. We're talking about strata title. Okay, dah ambil land law ke?
Dah,
Pernah dengar strata title?
pernah.
Okay, strata title adalah title untuk non-landed properties, right? So strata title adalah title yang akan dikeluarkan kepada apartment ataupun flat macam tu ya. Bila you jual beli apartment ataupun flat, normally strata title belum ada. Okay, fresh from contractor, you dah bayar semuanya dan belum keluar lagi strata title. That is very normal ya. Kita terpaksa tunggu. Sometimes it takes several years untuk dapatkan strata title di atas nama kita. Faham? Daripada nama developer tukar kepada nama kita, mengambil masa. Alright. So bila you dah beli, dah bayar pun, okay, dah buat loan, okay, title tak ada lagi atas nama you. That is very normal. Okay. So what you have to do is, bila you nak jual property tersebut kepada orang lain ataupun semasa you beli pada kali pertama, lawyer akan prepare documents to assign, okay, the first owner's right to the property to you. Assignment of rights. Faham? I thought I don't know whether I covered this in equity 1, and I don't know whether you remember. Assignment of rights. Beneficial interest, equitable interest. Tak ada legal interest, then we go back to equitable interest. Does this ring a bell?
A little bit.
Yes, Doktor.
Yes. So kita tak ada legal title. So how are you going to protect your rights? Okay. When you purchase a property without a title, so you need a legal document to safeguard your rights, and this legal document is called a document, a deed of assignment. Okay, kita assign, okay, the rights of the first owner to you as the purchaser. Alright, and then bila you nak jual lagi kepada another person, being the second purchaser, you need to also hire a lawyer to reassign your rights to another buyer. Doesn't mean that if you don't have the title in your name, you cannot transact, okay, whether to buy or to sell a property. Okay, so that's why equity comes into play. Yeah? Right. So in the absence of a title, the proof of ownership lies in this chain of assignment of ownership. Encumbrances. Ni semua dah I I guess you have come across in the land law, kan? Betul tak? Land law, encumbrances, ya. So in order for you, a simple land title, if you want to know whether you have any encumbrances on your title, you will have to do a simple land title search. Okay, dekat situ dia akan cakap sama ada title, especially kalau you nak beli a new title, you pergi pejabat tanah, you check sama ada terdapat, I don't know what the term in BM is, terdapat macam halangan ataupun syarat. Okay, syarat-syarat sekatannya terhadap tanah tersebut. Mungkin tanah tersebut dipajak dan dimiliki oleh kerajaan negeri. Mungkin tanah tersebut terdapat charge. Okay, apa maksud charge dalam BM? Gadaian. Pernah dengar gadaian? Tanah tersebut adalah tertakluk kepada gadaian bank. You nak beli ke tak tanah macam tu? So, you kena tengok semua tu. You kena check. Alright? So, while this charge exists, the property is locked and cannot be sold or transferred until the charge is removed or discharged. Okay? Kalau, let's say you want to further sell the property to your buyer being the second purchaser. Okay, tadi you dah buat loan bank. Nak beli daripada developer tak ada duit, buat loan. Okay. Bank tu akan buat charge atas property tersebut. Dia akan buat satu gadaian di atas property tersebut. So bila you nak jual kepada a new purchaser, you kena discharge dulu. Okay. Macam mana nak discharge? Your second purchaser kena bayar. Okay. Buat full settlement pada bank to release your debt, okay? Barulah kita buat assignment tadi. So these are all the documents that will be prepared hand in hand. Okay, apabila a sale and purchase of a property is involved. Normally dia akan, kalau you buat transaction secara cash, tak banyaklah dokumen. Tapi kalau you ambil loan bank, bank tu akan buat satu gadaian. Kalau nak jual lagi, then you have to discharge dulu, okay? Dan buat sale and purchase, assignment of deed of assignment dan sebagainya. So where a charge exists on a property, in order to release the property to be sold, okay, you nak discharge, then what the lawyer has to do is to prepare for the redemption process, right? Redeem the property balik. Okay? So it involves redeeming the property from the bank by repaying whatever is owed to the bank as a result of the first or initial loan. Are you with me? Kalau you buat nanti you akan buat practical kan nanti, betul tak?
Betul.
Betul, okay. So, benda ni you akan tengok sebab ini adalah bread and butter of most of the firms. Ya, dia akan buat conveyancing dan sale and purchase of property is very common. Selain daripada kalau you buat civil, accident, very common. Kalau conveyancing, you buat conveyancing, you mesti tahu process of sale and purchase of properties. Right? So the sale and purchase will usually be structured in such a way that a portion of the purchase price paid by the new buyer is used to repay the bank and redeem the property. Right? So ini adalah discharge and redemption process. Right? Itu saja saya nak cerita. Nanti yang the rest tu you akan, kalau saya dulu buat professional practice, masa UIA, we had to prepare the documents. It's not under professional ethics, but under legal profession, right? There is another subject called the legal profession where we had to set up our, I think not firm lah, macam group of, macam working group, dan kita buat sale and purchase and discharge, redemption documents semua sekali tu. Deed of assignment, we had to actually go to our own sources, find our own sources and prepare them and submit. We had to submit individually, ya. And then saya ingat masa tu saya tak score pun, tak cantik dokumen saya. Okay? So masa you practice, masa you buat practical nanti, please masa tu ask for the opportunity to look through all these documents. Okay, familiarize yourself. Mungkin you akan ingat balik apa yang saya cerita ni. You akan tengok, okay, in detail bagaimana proses tu berlaku. Dan bila you practice nanti, this one is a big contributor to your legal fees. Okay, sebab you akan dapat legal fees based on the scale of fees for conveyancing matters. Ada dalam order nanti Mrs. Wan Juhrah akan terangkan insya-Allah. Tapi ini adalah the luxurious part lah. Kalau you dapat involve and conduct dalam melibatkan transaction yang nilai propertinya besar, maka besarlah bahagian yang you dapat sebagai lawyer. Okay. Okay, so kita unshare this one. And let's go back to the slide. Okay, so the questions around, representing one party will be whether it is possible for an advocate and solicitor to also act for two parties or maybe more than two parties at the same time. Is it totally prohibited because of the conflict of interest? Okay. So a lawyer may only act for one party but may witness the execution of any documents or instruments by any party. This is one of, not to say exceptions, but this is one of the ways in which it is not, witnessing is not prohibited, right? A sale and purchase is one transaction and a loan is another separate transaction. Remember, nak beli apartmen dekat belakang, maybe dekat belakang Aeon tu, okay, you ada 300,000 cash ataupun 400,000 bolehlah beli. Okay, kalau tak ada, pinjam dengan bank, right? So, ada loan transaction. Therefore, a lawyer can act for a seller or buyer, sama ada on behalf of penjual atau pembeli dan, okay, yang tadi or, you're not supposed to act for a seller and a buyer, ya. Kalau ikutkan tak sepatutnya. But you may also act on behalf of a lender, right? Ataupun on behalf of a borrower, okay? Bank, ya. Bank yang bagi pinjaman tu mungkin lantik you juga sebagai lawyer mereka untuk selesaikan loan dokumen. Okay, so you dapat lagi fee daripada bank, fee daripada pembeli ataupun penjual dan juga fee daripada bank, right? So this solicitor concern should have regard to any possible conflict of interest situation, but you have to step back sekiranya terdapat clear case of conflict of interest. Okay, nak cakap macam mana? Normally, in normal practice, banyak juga firm yang act for both, yes, on behalf of the bank that gives out the loan as well as on behalf of the buyer. Alright, normally in my experience, buyer and lender. Okay. Tetapi jika ada conflict of interest situation, maybe you have acted for the bank before, okay, and now you acting for them again. Yang tu kalau panel tu biasalah. Okay, cuba tengok situations where conflict of interest may arise. Sama ada you have any relative in the working in the management of the bank dan sebagainya yang membuatkan you tidak dapat bersikap unbiased terhadap kedua-dua belah pihak, maka you have to step back, right? Kalau tak ada orang report, tak ada masalah. Tapi sekiranya ada orang report, pihak tak puas hati, sama ada pihak ketiga or your own client, maka terdapat masalah lah nanti ya. In a case whereby the property sold is encumbered ni sama ada dia tertakluk kepada charge atau sekatan-sekatan lain. Okay, so seperti if you check on the title, this property is subject to a 30-year lease, okay, and shall not be sold. Ada syarat dia ya. Contohnya tanah itu adalah tanah pertanian, dia tidak boleh dijual untuk tujuan komersial. Ini adalah satu sekatan juga ya. Sekatan boleh jadi pelbagai bentuk. Sama ada dalam bentuk gadaian ataupun syarat-syarat selanjutnya. Okay. So if the property is encumbered by the vendor, okay, orang yang jual, okay, charged to a financial institution and the vendor is not represented, tidak ada lawyer to represent, the vendor may engage the purchasers solicitors to act for the vendor in the discharge of the property from the financial institution. Ya. Sekiranya terdapat charge atau gadaian ke atas property tersebut, sama ada tanah ataupun bangunan, okay, dan vendor tersebut tidak mempunyai lawyer untuk represent dia, maka dia boleh engage the purchasers solicitor to act for him untuk discharge the property, okay, daripada gadaian tersebut, right? And the vendor will have to bear the legal fees for the discharge. So ini adalah case yang limited kepada discharge of the gadaian, ya, bukannya sale and purchase. Sale and purchase, maybe the vendor needs to have another lawyer, but only for discharge transaction. So ideally, the best scenario is the vendor and the purchaser should each seek separate legal representation. Sepatutnya mereka ada lawyer masing-masing, ya, to ensure that their respective rights and interests are fully protected. Okay. In other words, the vendor's solicitor shall act for the vendor. Okay. In the sale, in the discharge transaction, if there is any, and in the application for consent to discharge, ya, and the submission of the vendor's real property gains tax return. Ini untuk pembayaran cukai. Ini semua lawyer punya kerja, ya. So ideally, lantiklah lawyer masing-masing, ya. The purchaser's solicitor then shall act for the purchaser in the purchase transaction and submission of the purchaser's real property gain tax returns. Kalau jual property buat kali kedua, kerajaan akan kenakan real property gains tax, ya, berdasarkan kepada harga jualan, ya. Beli kali pertama tak ada lagi, tapi bila you start jual, okay, jual kali pertama belum lagi, jual kali kedua dah mungkin tertakluk, ya. If a purchaser requires a loan, the purchaser solicitor may act for the purchaser's financial. Macam saya kata, normally dalam kes yang saya pernah lihat sebelum ni, lawyer act for pembeli dan juga financial, bank, CIMB ke Maybank ke yang bagi loan untuk purchaser tu bayar property tersebut, ya. And this is ulangan. 3 solicitors. If the purchaser's financial does not appoint the purchaser's solicitors to act for the financial in the loan transaction, then 3 solicitors may be involved. One for the vendor, one for the purchaser, and one for the purchaser's financial. Okay, ini memang buat duit lah. Semua dia sapu ya. Vendor, purchaser, purchaser's financial, which is quite risky ya. Okay. Setakat tu mungkin blur sikit because you tak biasa lagi dengan conveyancing. Alright. Cuba baca, get your try to familiarize yourself with documents involved in conveyancing. Alright. Banyak law firms yang buat articles ya. Sometimes very basic articles that can educate us on the transactions they deal with, okay, for their clients, and what are the things, the do's and the don'ts. Semua tu kadang-kadang boleh baca daripada website of any law firm, ataupun mungkin boleh pergi kepada bar council punya dia panggil dia macam articles juga, very short explanatory articles, right? No advocate and solicitor to accept remuneration in their capacity as member of parliament, okay, accept emolument as member of parliament. So yang ni adalah rule 7. Okay, cuba tengok rule 7 of, is it LPPE? Saya lupa pula. Cuba check sekejap. Okay, LPPE ya. Betul?
Betul, doktor.
So dia tidak boleh menerima gaji, tetapi boleh menerima emolument saja. If he does accept in his capacity as a member of parliament or of any state legislature, other than emoluments received by him as a member of parliament or of any state legislature. Alright, no advocate and solicitor may accept the position of an executive director or executive secretary without the express consent of the bar council. Yang the second one concerns with the position of a director or executive secretary of a company, but you have to get express consent of the bar council. Okay. For A, it concerns with a lawyer who is also a member of parliament. Okay, you may not receive your salary, but only emolument as member of parliament unless you give up your profession as an advocate and solicitor. Okay, this one is acting as witness, so he must not appear in a case where he is a witness. He must not represent anybody in a case where he is also a witness. Rule 28. Okay, and an advocate and solicitor shall not appear before an appellate tribunal if in the case under appeal he has been a witness. Okay, sekiranya pada trial peringkat pertama a lawyer has been a witness, he must not represent a client in the first trial. Okay, at the appellate level, ya, tidak boleh. This rule doesn't prevent an advocate and solicitor from swearing or affirming an affidavit, akuan bersumpah, okay, berkenaan dengan apa-apa fakta in which he acts or appears. Okay. sharing of profit, rule 50. Apa maksud sharing of profit? So you are not supposed to share any part of the cost that you receive or the profits of your business with any unqualified person, bukan partner you, okay, ataupun bukan LA ataupun legal assistant you, alright. For an advocate to pay, give, agree to pay or agree to give any commission, gratuity, consideration, etc., or for having procured or influenced any legal business, okay. So it is improper to pay or agree to give any commission, blah blah blah, okay. Whether such payment, give, or agreement be made under the pretext of services rendered or otherwise, okay. But this rule doesn't prohibit the payment of ordinary businesses to staff, okay. So yang ni yang melibatkan pembayaran kepada unqualified person, orang yang bukan diterima sebagai peguam bela dan peguam cara. Tidak dibenarkan kecuali untuk bayar bonus ataupun gaji staff, okay, kerani ataupun you punya delivery boy, okay. What about C? For an advocate to accept or agree to accept less than the scale fees laid down by law in respect of non-contentious business. Okay. So, macam saya bagi tahu, untuk non-contentious, dalam cases of conveyancing ada scale of fees. Scale fees ni ada dalam one of the orders, remuneration order concerning fees and remuneration. Berapa persen for the first 10,000 and then berapa persen you boleh ambil for the next 50,000. Maybe you boleh check dalam remuneration punya order, okay. You must not accept less than what the scale fees prescribe, alright. Supposedly, okay, tidak charge less than that, okay. And then untuk contentious, apa maksud contentious business? Anybody? Apa maksud contentious? Yang kena faham lah. Non-contentious dengan contentious. Anybody? Apa maksud contentious business here?
Means controversial business.
Bukan. Maksudnya adalah macam litigation lah. Litigation untuk criminal ataupun civil case yang ni untuk contentious. Non-contentious maksudnya documentary work lah. Buat dokumen, buat agreement untuk bank itu masuk conveyancing lah. Faham? Itu non-contentious. Tak perlu pergi court. Sometimes you jadi lawyer, you duduk buat duit dengan sign agreement je. Okay, kebanyakannya kerani je buat sebab standardized documents. Dia dah tahu kerani tu, especially kalau dah 20-30 tahun kerja, dia semua buat, you sebagai lawyer sign je. So, bila sampai waktu dapat loan bank tu biasanya dah termasuk legal fees, okay, daripada loan bank yang klien you buat untuk beli property, you dah ada portion untuk bayar pada dokumen yang you buat untuk selesaikan transaction tersebut. Itu adalah conveyancing, non-contentious. Kalau contentious, okay, you kena represent a client in a trial. Okay, accident ke, kes bunuh ke, kes kecurian ke, itu contentious. Okay, untuk contentious, dia tak ada scale fees, okay. Itu adalah tertakluk kepada persetujuan lawyer dan client. Right, kalau you ni ada reputation seperti siapa lawyer DS Najib, Tun Razak, siapa kenal? Tak tahu? Siapa lawyer Dato' Sri Najib?
Syafi'i.
Okay, so kalau you hire Syafi'i, berapa you ingat you kena bayar dia? Sama tak dengan you hire for instance Wan Juhrah ke another law firm dekat Nilai ke? Sama tak? The more famous, the more reputable an advocate and solicitor is in the case of litigation, business or contentious business, the higher the fees will be ya. Sebab kita tahu dia selalu menang kes ya. So harga dia adalah pada reputation dia lah. Okay, untuk conveyancing ada skala yuran. Okay, skala yurannya berapa persen daripada harga jual itu okay, you boleh ambil. Okay. Selepas tu berapa persen lagi you boleh ambil. So ikut skala tu. I hope you are with me ya. Kita tak cakap pasal sharing of profit. Tak boleh berpakat dengan non-lawyer, okay, because dia tolong you buat apa-apa you bayar kat dia, you sub pada dia, tak boleh. He is, especially if he is an unqualified person, ya, tidak diterima sebagai peguam bela, peguam cara, tidak boleh buat kerja dan terima bayaran kecuali dia adalah satu staff, okay, clerk ke apa ke, right? Kalau dengan partner you boleh share lah. Partner maksudnya dia juga adalah seorang qualified person. Okay. Saya rasa kita teruskan sikit lagi and our exercise untuk hari ini saya terpaksa tangguh pada nanti saya akan bincang balik dengan Syahmi ataupun siapa-siapa nanti. Okay, because I have another meeting. I just want to finish up on touting dan beberapa lagi conduct ya.
Okay.
Prohibition on touting. Alright.
Doctor,
Yes.
about that no division of cost,
Yeah.
I think there's an amendment to this rule because it's no longer rule 50 but it's rule 52.
Betul. Okay. Ini adalah slide yang saya tak update lagi ni. Ada yang saya update, ada yang tak update. Thank you for alerting me ya.
Alright.
Okay, 52 ya.
Yes,
Cuba
because
stop
50 has been revoked.
Alright, let's see LPPE ya. Muka surat berapa ni? Rule 50 ni?
Page 181. Same with rule 52.
181. Okay, so it's important ya untuk always have your rules and your LPA with you. Sometimes we miss out ya. So you boleh alert saya juga. Saya pun bukan dalam practice ya. So ini adalah practitioner punya slide. So kita pun ingat the rule is still applicable. So revoke and okay, so this one is revoke PUA 354/1 bila ya revoke ni. This is as of berapa? This is as of August 2018 ya. So dah setahun ya. Alright, so you said it's under 52 no division of cost or profit with unqualified person. 52 no division of cost. Let's see the content. It is unprofessional and improper for an advocate and solicitor to divide or agree to divide either cost received or the profit of with any qualified person. Sama tak dengan yang asal?
Dia ada tambah-tambah sikit je, contoh macam B tu for an advocate and solicitor.
Tak, for A dulu. For an advocate and
Divide.
solicitor to divide or agree to divide either
cost received
or
the profits of his business
the profit
with
of
the rest tu sama.
with any qualified. either cost received or the profits of his business. Apa beza dengan yang asal ni ya? Macam sama, sound the same. Tengok B pula. For an advocate and solicitor to pay, give, agree to pay or
Give any commission
okay, gratuity,
or valuable consideration
okay,
to any unqualified person to procure or influence
or
or for having procured or influence and
any legal,
business
okay,
and whether such payment, gift or agreement,
okay,
gift or agreement
be made
be made under pretext of services rendered or otherwise, but this rule does not prohibit the payment of ordinary bonuses to staff. Alright.
What about C? Ada C tak? C?
C ada. For an advocate and solicitor to accept or agree to accept less
Then the
than
skill
the scale fees laid down by law in respect of non-contentious business carried out by him except for some special reason where no charge at all is made. I think in terms of advocate and solicitor tu.
Tadi saya dah bagi tahu yang tu, betul tak? Okey, yang ni sama je kan? Apa beza yang saya bagi tahu tadi dengan yang 52 ni? Siapa boleh detect? What is the purpose of this amendment actually?
Ke disebabkan dia tambah perkataan solicitor tu, doktor?
Saya tak tahu sebab saya tak tengok yang asal, sebab slides ni pun daripada yang lawyer yang pernah ajar students last semester. Saya tak tahu dia aware ke tak. Last year was 2019. I don't know, maybe barulah masa tu baru berlaku amendment ni. But it would be good if you can compare 50 dengan 52 yang sekarang punya ya. To see what is the difference ya. Sebab apa dia amend ya. Revoke, bukan amend tapi revoke. Alright. Okay, let's move on dulu. Touting. Siapa tahu the meaning of touting? Siapa boleh bagi tahu?
Attempt to sell something.
Attempt to sell something. Okay. Contohnya kalau touting in practice ya, you may come across cases where accidents happen. Okay, dekat accident punya scene akan ada orang yang pergi dan bagi business card ya, business card untuk hire a lawyer, mana-mana law firm untuk you claim insurance nanti, insurance terhadap from the other party lah. Okay, so itu adalah salah satu bentuk touting ya. You are trying to do something to get a client for another person ya. You use the service of a third party normally untuk dapatkan client. Faham? Okay, kadang-kadang ada orang naik motor pergi bagi business card. Okay, kalau you nak pakai lawyer nanti you contact this firm. Okay, yang tu sebenarnya tidak dibenarkan ya, against the ethical rules and conduct ya. Okay, 51. Betul tak touting bawah 51?
Touting 51, tak doktor.
Not to do of cost touting. 51 kan?
51.
LPPE.
Oh yes. Yes. Betul-betul.
Yes, madam. Yes.
Okay. Can an advocate and solicitor pay or hire someone to introduce clients to him or to her? macam hire an agent untuk cari klien, okay? He or she shall not do or cause or allow to be done anything for that purpose, okay? Directly or indirectly, or which is calculated to suggest that it is done for that purpose, right? See section 94 yang ni bawah LPA, 94 3F, G and H. Kita tengok sekejap. Kot ada perubahan lagi. This is quite latest ya. Kita punya akta ni 94 3. Okay, ini adalah the meaning of misconduct, right? What amounts to misconduct? 3F, apa maksud F? The tendering or giving of any gratification to any person for having procured the employment in any legal business of himself or any other advocate and solicitor. Okay. Bayaran kepada seseorang yang telah berjaya memperolehi pekerjaan untuk you sebagai advocate dan solicitor, yang ni tidak dibenarkan, jadi menjadi satu kesalahan ya di bawah 94 clause 3 and clause F. G, what about G? Directly or indirectly procuring or attempting to procure the employment of himself or any other advocate and solicitor through or by the instruction of any person to whom any remuneration for obtaining. Ini adalah salah satu lagi bentuk touting. Sama ada you procure, you as a third party procure or attempt to procure the employment of yourself or any other advocate and solicitor through or by the instruction of any person, okay, whereby remuneration is given to that person for obtaining such employment, right? And H, what about H? Accepting employment in any legal business through a tout. Ini clear cut ya, disebut tout ya. Tout ni adalah orang yang you hire untuk dapatkan satu-satu kerja untuk you ya. So this is not allowed. Branch office 90, go to 59 LPPE again. Okay. No branch office without advocate and solicitor. Tidak boleh buka satu branch tanpa ada partner you ataupun ada legal assistant that is in charge there. Okay, saya pernah jumpa ya, dia letak kerani je. Okay, dekat branch office. Apa-apa dia tak pernah ada in the picture. I experienced this myself. I had to report to the bank. He was acting for me as the purchaser and also acting for the bank from which I obtained the loan ya. So dia ada branch office dekat, I think dekat Shah Alam, tapi tak pernah ada orangnya, tak tahu dia duduk kat firm mana. Dia ada a few firms, dia hanya letak kerani, very junior, and who could not assist me with the transaction ya. So I had to report to the bank sebab dia panel bank ya. Panel maksudnya bank tu memang hire dia untuk sale and purchase. So bank buat siasatan dan dia boleh digugurkan daripada panel list lah ya. And then no advocate and solicitor shall practice his profession in the states of Malaya in or as a partner of more than one firm at any time without the consent of the Bar Council. Kalau nak jadi partner dekat firm, lebih daripada satu firm, mesti kena dapat consent daripada Bar Council ya. So ini jelas ya. I hope the branch office shall not be in the same office as that of any other firm of advocate and solicitor. Tak boleh nak share satu office dengan another firm ya. No advocate, sebab kita banyak involve document yang sulit, confidentiality of your client's documents ya, will be at stake ya. So no advocate and solicitor shall practice his profession in the state of Malaya in or as a partner of more than one firm. I think sama yang saya cakap tadi. Yang lain pun sama juga. No division of cost. Yang ni kenapa berulang balik Is this the same slide je? Sharing of profit and no division of cost. Yang ini rule yang terbaru ya. Yang tadi sebenarnya saya pun tak tahu, keliru sikit. No division of cost ni tadilah kan? It's the same rule, right?
Yes.
So actually it's already there. Yang tadi saya tak tahu. Oh, okay. Now I understand. Sebab yang tadi tu adalah the revoke provision yang telah dikeluarkan ya, dibatalkan. Mungkin rule 50 tu tadi itulah wording dia as if seperti sama. I don't know the real wording of 50, the revoke provision. Okay, but please just make sure that you don't refer to 50, only 52 ya. Okay, appearing for another party. Yang ni kita dah also touch in our previous lesson if I'm not mistaken. Apa tu under apa tu topic 2 ke? Right, where in any matter or proceeding the name of any advocate and solicitor or the name of his firm appears on the record for any party or is known to be acting for a party, no other advocate shall knowingly agree to appear. Okay, so jika seseorang tu you telah tahu that the person is being represented by another advocate and solicitor, you're not supposed to also act, especially if it concerns the same subject matter, right? Appears for another party unless he could obtain the consent of the first name advocate, kecuali apabila dah ada consent daripada advocate and solicitor yang telah dilantik, or he is satisfied that the proper professional remuneration of the first name advocate has been paid, or he undertakes that the same will be paid, or he has, yang ni kena tengok cases dan you can understand ya. Alright, yang B ni, if I'm not mistaken, if the first lawyer that your soon to be client or maybe your potential client has hired has been fully paid dan tidak, is about to to be released from retention, yeah. And C, he has in ignorant that such name so appears on the record, already agreed to appear, okay, for such party and is unable by reason of circumstances or urgency to refuse for that party. Ini adalah keadaan kecemasan ataupun ignorance, ya. The first name advocate and solicitor is unwilling, ni under D ya, or has refused to act further for such party. Alright. So it's so required protect any lien which the first name advocate may have for cost. Okay. This one is apabila lawyer yang asal tak nak lagi atau refuse to act for the for such party, or if so required, if he in which event he shall protect any lien which the first name advocate may have. Okay, lien ni kita akan tengok sekejap lagi. Lien by lawyers, okay, 55 LPPE juga. Okay, tengok, kalau tak tengok nanti you akan jadi lost ya, sebab slides ni kan may differ, wording dia may differ daripada provision section, rule 50 tadi. Muka surat berapa? Siapa dah jumpa?
Page 182.
What is the time now? Saya takut dah terlajak masa.
It's 3:48.
182. Kita habiskan sikit lagi. 182. Rule 55. Okay. Okay. Boleh tak kalau ni kes banyak berlaku, saya dengar daripada lawyer yang praktis ya. Okay. Dah siap. Ini kerja you dah siap. Okay, dokumen dah complete, case dah selesai, bayaran tak dapat, ya. Your client has refused to pay you, then what do you do? What is your right? Okay. Except by way of securing his first to lien, an advocate and solicitor shall not otherwise withhold the client's papers to the detriment of the client. Okay, baca sikit saya punya note tu. Right. When your retainer comes to an end, you may encounter challenges in obtaining payment from your clients, okay, for your outstanding bill. So one of the methods in which you can secure payment, okay, is to claim a solicitor's lien. In other words, you are given the right to keep to yourself the papers of your client in case the client doesn't pay his or her fees. Okay. Dia dibenarkan untuk menahan legal documents, ya, yang sepatutnya di-release kepada klien you. You boleh setelah, okay, sehingga atau until and unless your client has fully paid your outstanding bill. I don't know whether this one is being practiced. Boleh tanya Wan Jurah nanti, dia banyak juga, ya, masalah-masalah begitu saya dengar, ya. So boleh baca artikel yang saya share URL di situ, okay? Yang tu is in the context of, I think, Canada. I haven't come across any article in the context of Malaysia. Mungkin ada, ya, kalau you cuba pergi cari dekat MLJ. Yang ni saya cari secara sepintas lalu saja, ya. 55, ya. Okay, ni adalah exercise. You boleh just prepare among yourself in your TLB. Bila ada masa lebih nanti kita akan discuss, ya. Untuk topik ni up to that only. Lepas tu next week apa exercise yang ada kita boleh discuss. Okay. At the same time, bear in mind that you can already start doing your assignment that I have given in the slides previously. Yeah, I think the earliest due is on June 30th. Betul ke?
Yes, Doctor, the written one.
Okay, tak panjang, saya 2000 patah saja kalau tak silap, ya. Okay. So untuk kelas coming next week, ya. Next week, please be prepared with your reading of some of the materials that I shared on the topic of ethics on fees and clients money. Betul ke? Yang tu yang 22 hari bulan. Saya ada share, kan?
Yes.
Baca. Okay, baca supaya you are not totally lost. Okay. Cuba tengok masalah-masalah yang dihadapi berkaitan dengan fees and money, accounts and taxes, alright? Kalau ada soalan, sebolehnya you prepare awal, okay? Dan bila ada Q&A, the lawyer bolehlah tanya. Sorry, this one is not on 22nd. Ethics on fees will be on 29, silap. 22nd is on ethics of lawyers in court. Betul ke?
Betul.
Okay, please read through apa-apa bahan, ya, yang you ada. Saya tak ada bahan dalam bentuk slides. Mungkin you kena cari articles lah. Buku pun nak pergi library susah. Saya punya buku ni banyak English textbooks, ya. Kita nak yang kalau boleh Malaysian context lah. Tak semestinya you ignore English ataupun foreign jurisdiction. Cuma kita nak lebih familiar dengan our own jurisdiction. Okay. Cuba cari dekat Bar Council page ataupun dekat firms punya. Boleh baca ethics in courts, ya. So nanti I will be in touch with Syahmi or any of you untuk plan for how the talk shall be conducted, right? Sebab the judge is not familiar on how to share slides, dia tak biasa semua orang buat untuk dia kata. Okay, so you have to, nanti saya akan minta slides dan kita boleh run the slides for him lah. Okay.
Okay, Doktor.
Kalau tak ada apa-apa, then just wait for my instructions or for any messages that I will share afterwards, ya. Ada soalan tak before kita bersurai? But before that, wait ya, stay online because I need to download the attendance ya, sekejap ya. Attendance, kita ada berapa orang sekarang? 41 ya. Out of berapa? 40 punya. satu daripada macam ramai tak ada. 48 ni KLB 2. KLB 1 ada
48, 49.
47 kan? 47 dalam senarai saya. So siapa yang tak ada tu sebab kita nanti kena submit juga record kehadiran ni ya. They also monitoring our online lessons. Right. Jadi make sure kalau boleh adalah nama you dalam record ni. Okay, do not drop out in the middle of the lesson dan sebagainya ya. Okay, saya rasa saya dah download. Ada soalan lagi tak sebelum bersurai?
Tak ada, Doktor.
Yang lain?
Tak ada, Doktor.
Clear ya, boleh start buat assignment. Okay, do not wait until the last minute and make sure assignment that you're going to submit must not contain any plagiarized portion ya. Saya intend to buat to set up my Turnitin. Saya belum buat lagi. InsyaAllah kalau boleh run that software, you boleh gunalah untuk kita assess your level of similarity ya, panggil similarity index ya, dia panggil dengan mana-mana publish article. Kalau boleh avoid any similarity lah ya. Faham ya?
Yes, Doktor.
Alright. So, macam tu we should thank you for joining our lesson today, and if you have any question you would like to ask, you can contact me directly or through your representative. Okay, kalau you tinggal message dekat sini kadang-kadang tak sedar, so alert me lah. Alright. Syahmi ke Fiuzah ke anybody lah. You can just WhatsApp me pun tak apa. Kadang-kadang saya lambat sebab anak saya pun menggunakan telefon juga untuk buat apalah classroom, Google Classroom dan sebagainya ya. Right. So thank you so much. I think that's all for today. Okay, we're done with
Thank you, Doktor.
Okay, don't forget to do your revision ya.
Alright.
Okay, thanks.
Alright,
Alright,
Doktor. Thank you. Assalamualaikum.
Thank you.